Ready for dictation? Start. The President of the nation is subjected to judicial review. Then there is no question of satisfaction of the selection committee being outside the scope of judicial review merely on the ground that the said committee is manned by high officers. Stop. Otherwise, also, even the nipper had responded to his master's voice, and the selection committee is manned by human beings who, being mostly the civil servants, are trained and accustomed as well to work in tandem with the political master of the day. The possibility of their responding to the call of the concerned political masters cannot be ruled out. Stop. Hence, the need for objectivity and transparency becomes imperative. Stop. While dealing with the specific issue of the satisfaction of the selection committee for assessment for promotion to the highest cadre, the Honorable Supreme Court has cautioned that mere fact that high officials are on the committee does not exclude the arbitrariness. Stop. Para. The relevant observations of the Honorable Supreme Court as contained in the judgment rendered in Radhesham Das Supra case are as produced herein below. It cannot be said nowadays, if one is aware of the facts and currents of the life, that simply because categorization and judgment of the service record of the officers are in the hands of senior officers is sufficiently safeguard. Stop. There has been considerable erosion in the intrinsic sense of fairness and justice in the senior officers by all concerned. Stop. From instances of conduct of many, some of the senior officers and men in high positions, it cannot be said that such erosion is not only unjustified. Stop. Therefore, the Honorable Supreme Court had asked the government to frame an objective and reasonable criteria for selection. Stop. Thereafter, only the detailed instructions, guidelines appear to have been issued. Stop. Hence, these instructions, guidelines are required to be meticulously applied and seen to be have been so applied. Stop. Para. Another argument by the learned counsel for the respondent that the court tribunal should not sit in appeal and therefore should avoid the judicial review of the assessment made by the selection committee is also liable to be rejected. Stop. There is a very thin line and sometimes even invisible one between the judicial review of an action and sitting in appeal over an action. Stop. The court can very well test an action qua existence of relevant material in support of an action and qua exclusion of illegality, irrationality, unfairness of procedure and malafide. Stop. If despite exclusion of all the above said factors, two views are possible on a particular factual gamut, then the court would uphold the view of the action taking authority and would not substitute its own opinion in place of the action taking authority. Stop. This is the only significance of the argument that the court should not sit in appeal. Stop. Para. Hence, it is clear that the arguments that there should not be any judicial review of the assessment made by the selection committee because it is manned by high officers because the reasons are not required to be recorded by it or because the court cannot sit in appeal over its assessment is an excessive generalization and if accepted would lead to total opacity in a process which otherwise is ordered to be rational and objective and requiring even recording of reasons in certain circumstances. Stop. Opacity is nothing but a tool to disguise the arbitrariness. Stop. The arbitrariness is a sworn enemy of the fairness and has also been held by the Honorable Supreme Court to be an antithesis of equality before law and equal protection of law guaranteed by Article 14 of the Constitution of India. Stop.